Commerce Clause. We are somewhere in the middle of this process, and hopefully you have been thinking about this question, number 5, elaborate on the direct and indirect effect from Schechter and Carter. Just as a recap of the Carter case before I move into the final section here, which hopefully I can finish in the next 15 minutes. We have the Schechter case, which talks about the end of commerce and where once the chickens come to rest, they are no longer in commerce, and thus there can be no regulation at the federal level. The Carter case looks at where we start and goes back to those case questions about manufacture, etc., and of course determines that mining and oil and other types of activities like this are not in interstate commerce because they have not entered into the flow of commerce yet. So in both cases, of course, there would be potentially an opportunity for the federal government to regulate, but only if this issue of direct and indirect effects on commerce becomes relevant. So that's partly why this question is important. So let me go ahead and start the PowerPoint again and move on to the next part of the chapter. One of the things that's happening in the mid-20th century, around 1937 in this case, where an NLRB versus Jones and Laughlin Steel Corporation emerges, is that there's quite a bit of political disruption. As most of you probably know, the United States had entered into a relatively significant depression. Much of what had happened in terms of the court's experience up until this point in time had been an advocacy for a laissez-faire form of economic system. So the federal government, and specifically the court, had tried to stay removed from regulating economic conditions. But as things worsened on the ground, this became less likely to be a compelling point of view for most of the American population. Congress got on board a little bit faster than the court did. And so one example, for example, of how Congress worked this was through the Wagner Act. National Labor Relations Act is another more formal title for it. And this was designed to help protect the rights of employees who unionized. Again, as with many of the other major pieces of legislation passed by Congress to try to regulate wages, to try to assure overtime, to limit child labor, etc., this was based on their power to regulate interstate commerce because, of course, much of what people did in terms of their labor, they argued, would have been in interstate commerce. Now, as you can imagine, given previous doctrine and the way that the courts had looked at interstate commerce, this may or may not get us anywhere. The court hadn't changed particularly, and as the text talks about, as the New Deal legislation, of which this was part, came on board, it also began to be struck down by the Supreme Court, who didn't think that it was the federal government's right to be interfering in business decisions. This sets up what is commonly considered to be a court packing plan. The court packing plan, the idea was that for every justice that was on the court that had reached a certain age and had not yet retired, they would be another justice would be added so that the number of justices would be increased. Now remember that the number of justices is not set by the Constitution, and so it was perfectly feasible that such a plan could work. One of the things that saved this court packing plan from coming into existence is what the book calls a switch in time, but in reality is just a number of the justices on the Supreme Court deciding that it was time to rethink their constitutional framework. And so what we see happening with the National Labor Relations Board versus Jones and Laughlin Steel Company is a manifestation of that switch in time. So this is what's happened. So let's look at National Labor Relations Board, which goes through the Wagner Act and talks about this. So in this case, the court is examining the issue of the flow of commerce and direct effects. So we're still talking about the same issues in terms of interstate commerce, but the court's going to come to a really different set of conclusions than they did in the earlier cases. So this is one of those moments, again, where we see a change in how the court is looking at a particular kind of doctrine. So what does the court decide? And again, remember, this is all in the context of labor strike and labor strife, I should say, and the ways in which things are not going well economically in the United States. So there's some quotes here on this PowerPoint slide that come from the text on page 435, and let's start with these as a way of thinking through what NLRB does. First, the court determines that, and this is a quote, the congressional authority to protect interstate commerce from burdens and obstructions is not limited to transactions which can be deemed to be an essential part of a flow of interstate or foreign commerce. The fundamental principle is that the power to regulate commerce is the power to enact all appropriate legislation for its protection and advancement, to adopt measures to promote its growth and ensure its safety, to foster, protect, control, and restrain. Now, I'm guessing that you can see how significantly different this is from what the court had been saying before. The flow of commerce before really sort of limited the amount of power that Congress had to control interstate commerce, and it kept it in a sort of really narrow framework. But if you add phrases like all appropriate legislation, it's for its protection and advancement, that you are designed to promote its growth and ensure its safety, then you broaden out quite significantly the control that Congress has over interstate commerce. And so one of the logics that's happening in this case is that they're not using different words. They're still going to talk about the flow of interstate commerce, but they're changing the scope of what that's going to mean. So they go on to say, and again, this is still on page 435, although activities may be intrastate in character when separately considered, so think about pretty much anything that would happen within the state in terms of manufacturing or mining, etc., all the things that had already been discussed in previous cases and determined not to be part of interstate commerce. To continue with the quote, if they have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions, Congress cannot be denied the power to exercise that control. So again, we're looking at the direct-indirect link here and the logic of it. But what they're saying now is that if there's a close and substantial relation, then Congress gets to exercise control. So what NLRB does is really give more power to Congress to regulate what had only a few years earlier been unregulatable. And this is really known as the switch in time that saved 9, right? So we continue to have 9 Supreme Court justices, in part because a decision like this can be made and they can reinterpret what interstate commerce does. So let's look at how, again, excellent drawing on my part, let's look at how regulation of commerce changes post-NLRB and then, of course, also post-United States versus Darby, which does a similar kind of thing to what NLRB does. As you can see, we have the same sort of interstate flow of commerce here with the truck, but now what happens within the state and what happens on the other side of the state is also considered to be part of interstate commerce, as long as there is, of course, a way in which not regulating it would lead to an obstruction or burden, and additionally, if there is a close and substantial relation to interstate commerce. And so it's pretty likely that you could make an argument for why something has a close and substantial connection, and you see the court making that over and over again in some of the next cases. This brings us to the last case here. I'm kind of skipping over the Darby case a little bit. I figure you can do that on your own. But this brings us to the last case, and one of the ones that some of you may have briefed, and to the last question. And this is, where does Wickard versus Filburn leave interstate commerce doctrine? Specifically, how does the court define this issue of direct, indirect effect on commerce? So as you know, Wickard versus Filburn, 1942 case, looks at the 1938 Agricultural Adjustment Act, which does a lot of things in terms of our agricultural production in the United States. I particularly like the picture in the book of Mr. Filburn sitting in his grain silo holding a bunch of grain. So one of the things that's interesting about this case is that Filburn, who has a small farm in Ohio, has been producing things to sell, right? So he is in commerce, but he has also raised a variety of things, including wheat, on his farm to help feed his own cattle, his own chicken, and so basically for home consumption. So some of the wheat that he uses doesn't go into the market, it stays on his farm. What's at issue here, of course, is that he's allotted a specific number of acres to be planted with wheat, and he planted more than his allocation under federal law. As a result, he was fined. He refused to pay the fine arguing, of course, that Congress has exceeded its power to regulate commerce when it's saying that it can regulate wheat he produces for home consumption. So this is an interesting case, right? Because it's actually not talking about commerce at all. It's talking about the opposite of commerce. It's talking about the lack of commerce, or really what's happening on a farm without any effort to try to put that into commerce. So if we go back to this diagram, we're talking about something that's happening here that never even enters a flow of commerce at all. So how far has the cart gone is part of the question here. Now, some of you have briefed this case, and there are a couple things that I wanted to highlight about it. But otherwise, I think that you can come to some conclusions about what this issue is and how the court ultimately makes its decision on its own. But I want to read a couple of the quotes from it, and then you can use those to help make your own answer to question 7 pretty relevant. The first is, but even if appellee's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce, and this irrespective of whether such effect is what might at some earlier time have been defined as direct or indirect. So think about how that broadens out the doctrine and gives Congress a certain kind of control that it didn't have before. They go on to say, and this is on page 444, the effect of consumption of homegrown wheat on interstate commerce is due to the fact that it constitutes the most variable factor in the disappearance of the wheat crop. Consumption on the farm where grown appears to vary in an amount greater than 20% of average production. The total amount of wheat consumed as food varies, but relatively little, and use as seed is relatively constant. So they go on. The appellee's own contribution to the demand for wheat may be trivial by itself, is not enough to remove him from the scope of federal regulation, where, as here, his contribution, taken together with that of many others similarly situated, is far from trivial. So what they're saying ultimately is that while his individual contribution or lack of contribution to the market may be trivial, if you talk about everybody producing for home consumption, so feeding their own families with food they grow themselves, it does have a negative effect on the market. Direct or indirect might be the question. But here they're claiming direct, and because it has a direct effect on the market, ultimately, it falls under Congress's ability to regulate. So as you're answering question 7, elaborate on how they define this notion of direct and indirect effect, and give me a sense of what you think about how the court has done this. Because it seems, from what we've already studied in terms of the rest of the Interstate Commerce Clause, that the courts have gone from one relatively extreme position where very little was able to be regulated because it didn't fall into interstate commerce, to the very, very opposite effect, which is that they can regulate pretty much everything because everything implicates at least commerce, if not interstate commerce. So this is an interesting case to stop with, and of course we will be continuing on with the interstate commerce chapter when I return. Hopefully you'll continue to read through the chapter and be ready to talk about it in a week or so. In the meantime, make sure that you watch the video and write your review essay for that. Again, you can come to class to do this, or maybe you're in class doing it right now. Either way, I hope that this has been a relatively painless experience, and we will resume class in a week. Talk to you soon.